Hello, and welcome to Litigation Corner, a series where we discuss important issues affecting our community and shine light on successes achieved in the justice system. My name is John Martino, and I'm the Director of Litigation for Community Legal Services, a legal aid program that covers 12 counties coast to coast in the middle of Florida. Last episode, we talked about evidence, when you can present evidence, what are the types of evidence, and how you can enter things into evidence. This week, we're going to focus on a litigation tool that is used to keep things out of evidence, objections. So sit back, relax, get your notebooks handy, and welcome to Litigation Corner. One of the leading reasons why having an attorney is often preferable is because attorneys understand the rules of evidence. One scenario where that understanding can be very important is when objections are made during a hearing. In court, you'll hear lawyers, or even the opposing party, object to certain things. An objection is when someone challenges something that is being said or presented in court. There are rules about what can be said, what evidence can be shown, and how things should be done. If you're representing yourself, you need to know about objections so you can protect your case. You don't need to be a lawyer to raise an objection, but to be an effective advocate for yourself, you should at least have some understanding of the most important evidentiary objections. Here are a few common objections that you might encounter or need to raise. Relevance. If something is being said or shown that doesn't relate to your case, you can object to it on the grounds that what is being discussed or shown is irrelevant. For example, if the other party is talking about something that does not have anything to do with the case, you can stand up and say, "Objection, relevance." By doing so, you are asking the judge to rule on the relevance of what is being discussed. The judge can then ask you for more information, ask the other side to explain, or if the judge believes they can rule on the objection without further discussion, they may do so. Next up, hearsay. Hearsay is when someone tries to introduce a statement made outside the courtroom. That statement can be from a person testifying or something stated in a document. The rule against hearsay is important to understand because it can be tricky. If someone begins saying, "My friend told me that," the remainder of that statement might be hearsay, and you can object. But there are a substantial amount of hearsay exceptions. For example, if you are in an injunction hearing, each party may testify to what the other party said outside the courtroom. That is because they are party opponents of each other, and that is an exception to the hearsay rule. Other common exceptions include statements made during an exciting or startling event, statements made to healthcare providers, and public records. Each one of these exceptions has its own rules, but just having a basic understanding of what hearsay is could help you in the courtroom tell your story and make sure that the other party is not inappropriately telling their side of the story. So, if the other party or another witness is about to say something that someone else said, you can stand up and object to hearsay. Next up, leading. A leading question is one that suggests the answer. For example, "You were at the scene, weren't you?" is a leading question because it pushes the witness toward a specific answer. You can object to leading questions, especially if the other party is asking them during their direct examination. However, here's a tip that you need to know. Not every leading question is inappropriate. During cross-examination, when the other party or their attorney questions you, or when you question the other party, you are allowed to lead the witness. In fact, it is advisable that when you are doing cross-examination, that you should lead the witness to direct them to the areas of discussion that you want to bring them to. Okay, so to wrap up the discussion from these 2 episodes on self-representation, let's talk about some tips that can help you feel more confident and prepared as you represent yourself in court. Be organized. Gather your evidence in advance and make sure it's clearly labeled and easy to access. You don't want to be scrambling during your hearing. Keep everything in a folder or a binder. Stay calm and respectful. Court can be intimidating, but it's important to stay calm, respectful, and patient, even with the other side or their attorney. The judge is there to make sure the law is followed, so being respectful to the court is crucial. Practice your story. Know your case inside and out. Be ready to explain the facts clearly, logically, and calmly. Practice what you are going to say. Also, if the facts of your case happened over a period of time, I would strongly suggest that you prepare a timeline with dates and important events so you have something to reference during the hearing. Know the rules. Familiarize yourself with the basic rules of the court. What time should you arrive? How should you address the judge? That is typically Your Honor, or you may say the word judge and their last name. Ask questions if you don't understand. If you don't understand something, ask. It's your right to know what's going on, and the court can often explain things in a way that will help you. Remember, even without an attorney, you have a right to be heard, and as we've stated today, you have a right to object to keep out evidence that is not relevant to the case. You have the right to present your case, and most importantly, you have the right to advocate for yourself. It may feel overwhelming at first, but with preparation and confidence, you can do this. Be organized, be clear, and stay calm. The court is there to listen to your side, and by following the steps we've talked about in these first 2 episodes, you're setting yourself up for success. Now we're going to move on to the story about how Community Legal Services recently helped somebody. When Ms. Bennett first walked into our office, she was facing a difficult and stressful situation. Recently evicted from a short-term hotel due to her inability to pay, she was unsure of what her future held. Ms. Bennett had physical limitations, and without an income, she couldn't make ends meet. It was clear that she was struggling, but after listening to her story and asking thoughtful questions, we realized she was eligible for Social Security disability benefits, something she had never applied for before. Understanding that navigating the complexities of Social Security disability can be overwhelming, we immediately got to work on her behalf. We filed an initial application for SSD benefits, but unfortunately it was denied. However, we didn't stop there. Our team continued advocating for Ms. Bennett and filed for reconsideration. It was through this second effort that her benefits were approved, securing her a monthly income that would change her life. In addition to ongoing financial relief, Ms. Bennett received a back payment of more than $11,000, which helped her stabilize her situation. With monthly SSD benefits now in place, Ms. Bennett was able to find stable housing. Ms. Bennett's case demonstrates the power of our holistic approach to legal services. We don't just focus on the immediate legal issue. We take time to listen to our clients' stories, uncover hidden legal opportunities, and work tirelessly to provide long-term solutions. Our firm is proud to have a medical legal partnership with the Christian Service Center in Orlando, an organization dedicated to preventing homelessness. Through this partnership, we were able to combine our legal expertise with social services to offer our client a seamless support system. Ms. Bennett's case is a testament to the power of collaboration. Eric, an attorney with our MLP unit, and our friends at the Christian Service Center helped Ms. Bennett regain her stability to avoid further hardship. We're grateful for the opportunity to serve clients like Ms. Bennett and are proud to be part of the solution that prevents homelessness and supports those in need. Thank you to our incredible partners at the Christian Service Center and Eric from our MLP unit for your continued collaboration. Together, we make a difference. And that is a wrap on this episode of Litigation Corner. If you have a topic you'd like me to cover in a future episode, please write it in the comments. And remember that when you need help, or a friend needs help, Community Legal Services is there for the community. See you next month at the Litigation Corner.